Mayor Simbayan, distinguished council members, dedicated staff, I'm Jason Flanders of the ATA Law Group, here tonight on behalf of Fresh Air Vallejo. First, I wanted to note that Vallejo Marine Terminal LLC has recently been suspended by the California Secretary of State, and you can see that on the Secretary of State website right now. A suspended corporation such as Vallejo Marine Terminal LLC has no authority to conduct business in California and no capacity to initiate any legal proceedings. This leaves the council now with two options. Deny the appeal and or drag this out longer until VMT comes into compliance with the law and regains its active corporate status. Because VMT has no legal capacity in California while suspended, its appeal is arguably a nullity, and any city council grant of this appeal here would arguably be a nullity as well. The appeal itself is legally without merit and principally relies on the erroneous assertion that the Planning Commission was required to certify the EIR. However, the statute states that CEQA, quote, does not apply to projects which a public agency rejects or disapproves. And the Court of Appeals held that even where a city has, quote, initiated environmental review, there's no duty to complete the CEQA process if an agency at any time decides not to proceed with the project. The law here, in fact, is so clear that appellants' dogged persistence of this argument genuinely does call into question their credibility and viability, as does their inability to comply with even simple Secretary of State procedural requirements, resulting in their corporate status being suspended. A certified EIR is not required. The city considers many projects that are exempt from CEQA without a certified EIR. The true standard here is whether the decision is supported by substantial evidence, and even where there's conflicting evidence in the record, the city's determination will be upheld where it's based on some fact, which staff has ably done here. Applicants' arguments earlier that they were induced to this point or that the city approved the project with a lease agreement seek to undermine the city's authority in ways not permitted by law. The Planning Commission was right to deny the project. It would have significant adverse air quality, greenhouse gas, traffic, public safety consequences, all in violations of applicable legal standards. The project would still require a major use permit because it's a multimodal industrial facility that includes shipping. If returned to the EIR, numerous issues would need to be resolved and recirculated for public comment. There's significant question about a majority of the project site. The air quality and BCDC permitting requirements have changed. The EIR doesn't assess the unsanctioned dredging proposal of the Mare Island Straits Economic Development Committee, which relies on this project to occur, and therefore is at a minimum reasonably foreseeable indirect effect of this project. And the project documents still failed to ensure that coal and petcoke would not be within the permitted use of the facility, relying on vague and equivocal language, the likes of which has gotten the city of Oakland embroiled in years of litigation. Thank you.
Thank you.